Who decides who can carry a firearm onto your property and under what conditions? Does the Second Amendment presume permission or restriction? According to the Hawaiian legislature, they decide who carries and presumes restriction. So we'll talk more about this next on the Constitution Study.
Lovely neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach our generation be free. Glad you could join me today. You know, gun rights are always a hot topic. I love to come here on the Constitution Study. However, there are certain states whose, well, we'll just say antagonism to the Second Amendment really is outstanding. And one of those, well, is the state of Hawaii. We'll talk about that case coming up. If you want to follow along, we'll head to the website, constitutionstudy.com. You can find this article, which not only includes, well, all of my sources, but links so you can follow along with me. Now, I'll talk more about the website and what you can do there at the end of the episode. But for now, let's talk about this case about the state of Hawaii and gun control. The state of Hawaii has a history of antagonism against the Second Amendment and the people's right to keep and bear arms. For years, the state of Hawaii made it almost impossible to obtain a license to carry a firearm. 4 years ago, however, this court held in New York State Rifle and Pistol Association v. Bruin that the Second and 14th Amendments protects the right to carry handguns outside the home for self-defense. Hawaii responded by replacing its old law on carry permits with new laws that achieved a similar result. At issue in this case is a Hawaii law that prohibits firearms on private property open to the public without the express and affirmative consent of the property owner. Who gets to decide when someone is allowed to carry on your private property, you or the state? Now, according to the Hawaiian legislature, people need express affirmative consent from the owner to carry on their property. This means before you walk into a convenience store, doctor's office, or even a parking lot, you need express affirmative proof that you have the owner's permission. Now, express is that which is express, is laid out in words. And affirmative means averring a fact to be true, that which is opposed to negative. Now, imagine requiring proof you have permission to enter a business open to the public. What if they don't like the saying on your t-shirt, or the color of your pants, or the fact that you have a child in a stroller? Yes, private property holders can deny access in any of these cases, but nowhere does a legitimate government require proof of permission to exercise your freedom of speech, press, or liberty before entering a publicly accessible location. Hawaii's new rule imposes severe restrictions on the daily activities of residents who have satisfied the state's rigorous requirements for the issuance of a carry permit. When these permit holders leave home, not only must they take care to avoid all territory where the possession of a gun is prohibited outright, but they must also be barred from entering any places that people routinely visit in the course of their daily routines, such as gas stations, restaurants, and stores. This law flips the default rule at common law, under which anyone has an implied license to enter property held open to the public unless the property owner withdraws consent. No one is saying that property owners cannot prohibit those carrying firearms from entering their property. All they have to do is post a sign at the entrance with the infamous no gun image. However, what Hawaii is trying to do turns public access upside down, but only for those who exercise their rights under the Second Amendment. In District of Columbia v. Heller, this court held that the Second Amendment protects an individual right to keep and bear arms, with the amendment's central concern being the fundamental right of self-defense. Heller instructed courts to ascertain the scope of the right by looking to history and emphatically rejected an ahistorical judge-empowered interest-balancing inquiry. So, according to the court, the central concern of the Second Amendment is the right to self-defense. That's partially true, since the Second Amendment also clearly states that a state's militia is necessary to its security. Now, petitioners, 3 residents of Maui County who possess concealed carry permits, and an organizational plaintiff with members who have such permits, filed suit in federal court seeking temporary and permanent injunctive relief, contending that the law at issue violates their constitutional rights. The district court enjoined enforcement of the law as applied to private property open to the public, but the Ninth Circuit reversed that injunction. Now, 3 resident petitioners sued in federal court, claiming Hawaii's law violated their rights protected by the Constitution of the United States. Personally, I think there's more to this case, but let's start with what the court found. As the court points out, Hawaii's law plainly falls within the text of the Second Amendment. Restrictions imposed by Hawaii's challenge law fall within the plain text of the Second Amendment, so the law is presumptively unconstitutional. No party disputes that petitioners are among the people protected by the Second Amendment, or that they seek to bear arms. Therefore, the plain text of the Second Amendment protects what petitioners want to do: carry handguns for self-defense. So the petitioners want to bear arms, including in publicly accessible areas of private property. But what about the owner's property rights? To be sure, owners of establishments that are open to the public can admit or exclude persons who are carrying guns for self-defense under either the common law rule or Hawaii's law. But Hawaii's shift from the common law rule unquestionably imposes a new and significant burden on the exercise of the right recognized in Bruin. As I mentioned before, any property owner who does not want people to be armed on their property merely needs to post a sign to that effect. In some states, violating that sign is merely trespass, while other states treat such violations as crimes. What about the reverse, though? Would people post a sign saying permit holders are welcome to carry on the premises? For example, proprietors who do not object to entry by carry permit holders may be reluctant to post welcoming signs for fear of alienating customers. Funny how the court, like so many people, isn't worried about alienating customers by telling them they're not allowed to carry on the premises. I have pointed out to several establishments the business I would not do with them because I was not welcome to carry on their premises. Under Hawaii's new default rule, a proprietor in this category may only be willing to consent discreetly to the entry of permit holders who make the effort to inquire. This arrangement imposes a new burden on permit holders who will have to somehow obtain permission to carry a firearm on the property before stepping foot on it. The law severely hampers the ability of law-abiding citizens to recognize the right Bruin recognized as they go about their daily lives. Now, for those of you who do not carry firearms, consider this. You're going about your daily life, doctor's appointments, shopping, possibly stopping for a bite of lunch. At every location you enter, you first look for a no firearms sign and avoid any locations that have them. Now you're in Hawaii, going about your business as before. Now, however, you cannot enter any business until you have proof that you have explicit permission to enter. While this law does not prohibit bearing arms in public, it makes it practically impossible to do so without violating the law. Hawaii claimed there are historical analogs to this law. The court disagreed. Hawaii's argument that its particular customs and laws support the new default rule fails because the Second Amendment has the same meaning in all parts of the United States. The Second Amendment cannot give way to the spirit of aloha in Hawaii any more than it can yield to the spirit of the Big Apple or the Windy City. Merely local attitudes can neither shrink nor inflate the meaning of fundamental Bill of Rights guarantees that apply to the states through the 14th Amendment. Now, the 14th Amendment argument mentioned here is nothing more than the ongoing devotion to an unfounded decision by the court in the case Barron v. Baltimore. Now, I discussed that case in my article, The Incorporation Doctrine, so you can follow along there. Now, Justice Alito is correct. The meaning of the Constitution doesn't change from state to state. And since, according to the Supremacy Clause, the Constitution of the United States supersedes the laws and constitutions of the several states, its meaning must hold over the local spirit, regardless of the state or city which holds it. Furthermore, it appears that the examples Hawaii brought are not even relevant to this law. The state's colonial and early state law and analogs consist almost entirely of laws that prohibit unauthorized hunting of deer or small game on someone else's private property. Those laws had little, if any, impact on the Second Amendment's central objective of protecting the fundamental right to self-defense, and their obvious aim was to prevent the distinctive harms and risks associated with unauthorized hunting. The gap between the state's anti-poaching analogs and its new rule is too wide. I don't know who enters a restaurant or store looking to poach animals, so I would agree with Justice Alito on this point as well. Now, both Justices Kagan and Jackson wrote dissenting opinions. However, Justice Kagan's dissent is in support of Justice Jackson, so let's go to the source of the dissent. Today, the court declares unconstitutional Hawaii's effort to protect the rights of its residents, both those who wish to carry guns and those who prefer that guns are not carried on their private property without their express permission. How, Justice Jackson, does Hawaii's law protect the rights of those who wish to carry guns? The answer is it doesn't, which means it infringes on the right to keep and bear arms, which violates the Second Amendment. Or, as Justice Jackson sees the majority opinion, to hear the majority tell it, Hawaii's law is a blatant attempt to end run our Second Amendment precedents. That does seem to be the purpose behind Hawaii's law. As I've already pointed out, it all but prohibits the ability to carry a firearm in public unless the person already has proof of explicit permission to carry in any publicly accessible businesses. If there is any possibility that I may need to stop at a location where I do not have proof or permission, I must either go unarmed or be prepared to violate Hawaii's law. Sadly, Justice Jackson doesn't see that. But the statute at issue does no such thing. Instead, it fairly applies a first principle of property law, the right to exclude, and does no harm to the Second Amendment. Hawaii's law does not apply any recognizable principle of property law because the law determines for the property owner the conditions under which they may allow a legally armed individual to enter their premises. This law actually violates the rights of the private property owners. Hawaii's law does not implicate the Second Amendment because there is no right to carry a gun onto private property without consent, as all agree, and the Constitution does not dictate the form of that required consent. We all agree that no one has the right to carry a firearm on private property without the owner's permission. But what role does the state of Hawaii have in determining said permission? After all, in all the other states, a private property owner who does not wish people to carry firearms on their property merely has to place a sign, a legally approved sign, to that effect on the entrance of their property. Now compare that to the property owner under Hawaii's law that in order to allow someone to carry on their premises, they must provide proof that the person is allowed. Could they place a sign saying, "Legal carry welcome," at the entrances of their businesses? Yes, but only because the state of Hawaii has decided their anti-gun bias lets them dictate to private property owners how someone may be allowed to lawfully carry on their property. That is a requirement placed on the exercise of no other right. Petitioners believe that having to ask permission to carry a firearm onto private property open to the public is an unconstitutional burden on their Second Amendment rights. But their bid to invoke the Constitution stumbles out of the gate at step 1 of the court's Bruin test. There is no constitutional right to enter private property without the owner's permission, let alone with a firearm. So the question this case presents is merely how a property owner must communicate his decision to exclude or invite armed carry, including whether a state may alter the background property law rules that set the default as one or the other. The Second Amendment has nothing to say about that. Petitioners' constitutional rights are thus not implicated here, and their claims should meet its end at Bruin's first step. For this argument to make sense, the court would have to require permission to enter the property at all. Why is Justice Jackson only targeting legal gun owners in her alleged protection of private property rights? Imagine logic being applied to any other right protected by the Bill of Rights. Before I enter a business, I must get permission to wear a t-shirt with a specific saying on it, or prove that the store will not require my ID except when legally required. Since Hawaii's law is the one infringing on the right to keep and bear arms by placing an unreasonable burden on that right, it violates the Second Amendment. By applying the need to get permission only to legal gun owners, Hawaii violates the Equal Protection Clause of the 14th Amendment, not some fictitiously based incorporation doctrine. Furthermore, I assume that law enforcement is exempt from this law, which means that they can enter private property while armed without the express consent of the owners. Or are police held to the same ridiculous standard which Hawaii wants to hold everyone else? Now, how did the court decide this case? Well, held. Hawaii's law prohibiting licensed concealed carry permit holders from carrying handguns on private property open to the public without the property owner's express authorization violates the Second and 14th Amendments. Hawaii's law violates the Second Amendment because it infringes on the right to keep and bear arms. But contrary to what the dissenting judges said, the law does not enhance or protect the property rights of the owners, since they have always been able to legally prohibit firearms on their property. What the state of Hawaii tried to do was make legal firearm carry burdensome, since the burden differential between the presumption of allowance versus the presumption of prohibition is not equal. Think of it this way. If the private property is open to the public, they want the public to come in. If they have any restrictions on that, it's up to the owner to post that on their signs. Otherwise, a legal firearm carrier could be denied access to a business not because the owner wants to deny them, but merely because they have not provided proof of their acceptance. Meanwhile, the burden of placing a sign denying access to anyone with a firearm is extremely small. Even without a sign, a property owner can simply trespass anyone who brings a firearm on their property, which has criminal consequences if the trespassed person does not comply. Add to this the unequal treatment under the law for firearm owners versus anyone else, and we see the 14th Amendment violation. This case, however, is not yet finished. The Hawaii law at issue here violates the constitutional right to keep and bear arms. Therefore, the judgment of the Court of Appeals for the Ninth Circuit is reversed, and the case is remanded for further proceedings consistent with this opinion. It is so ordered. Now, since the Ninth Circuit's decision is reversed, the District Court's injunction against enforcing law remains in place until the case itself is decided, hopefully following the Supreme Court's opinion. A right burdened is a right denied. So adding an unreasonable burden, and again, if you are an anti-gunner and you say, well, I don't want people with guns on my property, absolutely, put a sign up, that's your right. I've never challenged that. The question is, if you have to put a sign up permitting every possible permutation of who you want on your property, well, that becomes ludicrous fast. And that's basically what Hawaii is saying is, we're going to carve out this one, handguns. You have to prove, you have proof that you have permission, but not for anything else. The idea of Justice Jackson that, well, there's no real harm done is ludicrous. And the idea that they're enhancing private property owners' rights is baloney. Again, if you don't want firearms on your property, just put a sign up. If you don't want people in shorts and t-shirts, you can put a sign up. If you don't want vulgar language, you can put a sign up. You can do anything you want to trespass people you don't want on your private property. I find it interesting that probably in the state of Hawaii, they would fight most of those ordinances, except, well, the one about firearms. I don't know. Tell me what you think. Comment on this episode. Let me know what you think about this opinion and my analysis of it. Of course, you can head to the website, constitutionstudy.com, and comment on the article there, or send me a question. I have a whole section dedicated to questions. You can also email me at questions@constitutionstudy.com. The point is, we need to look at this, and I know a lot of people's visceral reaction against guns, they want the default to be no. If that's what they want, they can have that. They just can't impose that on everybody else. If you don't want firearms on your property, say so. You cannot tell your neighbor they're not allowed to have firearms on their property unless they give explicit consent. That is unjust, it is not equal protection under the law, and it certainly isn't infringement on the right to keep and bear arms. I hope you like the work that we're doing here, and I hope you like the content we're creating enough. Well, maybe give us a little bit of support. Head to constitutionstudy.com/shop and, well, buy something at the store. A book, a t-shirt, a mug, or just donate to the cause. Nobody here gets a salary. Nobody here gets paid for any of this. We pay for all of this. So when you can come along and help, it not only helps me keep this program going, it helps me speak at events without charging a fee. I prefer to, when I go to events, I don't like charging speaking fees. So when people support the work that we're doing here, I can pay for those costs without charging the venue directly. And I think it's worth it. I think it's important. So you can find out, constitutionstudy.com/shop. Anything you buy there, any donations you make, go to keeping the Constitution Study up and running. Of course, you can also support us with your cell phone. See, Patriot Mobile is America's only Christian conservative wireless provider. But that's not why I joined them. See, I partner with them because, well, they take a portion of every dollar they make and donate it to organizations that are fighting for your rights. Now that includes the Constitution Study. So if you go to patriotmobile.com/constitution, find a plan that works for you. When you pay your bill, you're helping support the Constitution Study. By the way, see if you're eligible for discounts. Families with multiple lines, veterans, first responders, and more get a discount, saving you even more money. And if you use the code Constitution at checkout, you get your activation absolutely free. So get great cell phone service, great customer support, a good price, and support the work we're doing here at the Constitution Study and other organizations that are supporting your rights just by going to patriotmobile.com/constitution, finding a plan and discount that works for you, and then don't forget, use that code Constitution at checkout for free activation. Most of all, I hope you enjoyed this day. I hope you enjoyed this episode. And I hope you'll come back next time and, hey, maybe bring a friend or two when we meet for the Constitution Study.